Yes, hello.
Hello, is that Mrs. A?
Yes, it is. Is it Cheyenne?
It is, yes, Sean calling from the Legal Ombudsman. Hello.
Yes, hello. Thank you for calling me.
No, but thank you for setting some time aside for me. What we'll do today, Mrs. A, is obviously go through your complaint that you've got with us. I just need to clarify some details with you and
Yeah, sure.
confirm what it is that you're looking for us to investigate. But before I go into any details, can I just run through some data protection questions with you to
Yeah,
confirm your details?
yeah, sure.
Thank you so much. So just confirm your email address.
Um, is it fatabegum at gmail.com?
Yes, yes, correct. And your full name
Mr. Sajjad Hussain.
and the solicitors that the complaint's against.
Burke Niazi Solicitors.
Brilliant. Thank you so much for that. So, basically, Steve, we're going to details. I just want to apologise for the delay that you've had with us. I know that your case has been with us for some time, and we are currently still with a backlog of cases with COVID, etc. But so I'm really sorry that you've had to wait, some time for us to look at this for you. But now I've been assigned as the investigator, I'll be handling the complaint moving forward. So I just want to ensure you it's my priority to get things going as quick as possible so we can try and come to a resolution for you and the firm, okay? So just to introduce myself a little bit and what I do as an investigator, you might have dealt with some of my other colleagues, but as an investigator, I'll be the point of contact for both you and the firm throughout the investigation. So just to make you aware, we're not here to take sides. We're very much an independent organisation, but we try and help you to try and find a resolution with the firm. I'm aware it's not always possible to find a resolution. I have looked through some details of your complaint, so we'll discuss that. And where we can't find a resolution, what we'll do is look to investigate your issues and ultimately come to our own findings and try and share them with you and the firm, okay? So I've gone through some of your, obviously the complaints form that you have submitted online doesn't contain too many details, but we have obviously contacted the firm when we made them aware that a complaint was lodged against them, and they have shared quite a few emails and letters that I think they've sent you or that you sent them regarding numerous complaints. So really what I'd like to do is just go through with you your experience that you've had with them and try and pinpoint the specific points of complaint that you've got against the firm. Is that okay?
Yeah, sure.
Brilliant. So good. I can see you've employed through legal aid, or you've sought their help in, was it April 2021?
That's correct, yes.
Yeah. So just tell me a little bit, obviously, about your experience with them.
Okay. So just before I do so, I mean, you've introduced yourself, and it's usually my policy to just determine who the who you're accountable to, or who the most senior person in your organization is. So would you be able to, just to start off with, would you be able to tell me who the chief executive is of your organization?
Yeah, of course. Well, what I'll do is I'll go through our process of how we deal with things, and I'll tell you who the chief ombudsman is. Essentially, what we do is investigation. If it got to the point where I have to issue my findings, you or the firm can dispute that, and if one of you or both of you disagree with my findings, then that can go to an ombudsman for a final decision. So what they would do is they would review my case and then issue a final decision. And then ultimately, if you were not happy with that final decision made by an ombudsman, we have several of them, then you could take that to a judicial review. But obviously, that is quite some time along the way. But essentially, that's our process. So, I mean, you can go on our website to find, who heads up the legal ombudsman, etc. But the process more leans towards, like I said, we would make a decision. Like I said, that's way down the line at this time. It goes to an ombudsman, they make a final decision, and ultimately, if you're still unhappy with that, or the firm may be unhappy with that decision, either of you can then go to a judicial review regarding it.
Okay, so just to confirm this, that right now, as an investigator, you have, although that you work under are employed by the ombudsman and work as the representative of the chief ombudsman, But you work quite independently at this early stages, and so there would be no senior involvement at this stage, because all you really do is just gather the information and to instigate an investigation. And once you've collated all that information and you're able to investigate it fully, then you're able to put forward a resolution. And if either party disagree with that resolution, then it goes to like a panel of senior ombudsmans, who can either overturn your decision or once again agree with it. And then if either party is still not satisfied with the ombudsman, the panel of ombudsmans, is there a process where if I'm not happy with the ombudsman's decision, that I can ask for another ombudsman to review your case findings?
So that's spot on for the most of that's absolutely correct. But ultimately, if you're unhappy with the ombudsman's decision, then that you would only challenge that in what we call a judicial review in the court.
I understand. So once the senior ombudsman, because you said there's quite a few of them. And I'm just trying to understand that their process is that final decision is made by a single ombudsman. It can't be like if that's a final decision. I can't say that. Well, I don't think that ombudsman is right. Can another ombudsman review? It doesn't work that way. What actually happens is that one of the ombudsmans makes a final decision, and if I'm not satisfied with that, I then go to the judicial review. Is that correct?
Yes, that's correct. So a single ombudsman would make the decision on it, and then the alternative would be to go to judicial review. For you or the firm, the firms can do it as well.
Yes.
To take it to judicial review. But like I said, we'd give plenty more information regarding the process of that at the end, if that is what it comes to. Yeah.
What's confused me a little is because you said there's quite a few ombudsmans. Because normally what happens, what my understanding is, because I'm just trying to understand, where you fit in this organizational structure. So for example, if you say, look, I'm basically because you understand the ombudsman is like there's one person in there, the chief executive, that everybody works under. So if there was if your investigation findings were reviewed by the chief ombudsman, then I can understand. But because what's thrown me is that you said that there are a few ombudsmans. That's what kind of confused me, you see. Because then I presume that those ombudsmans are under the chief ombudsman. And I just wanted to know that at what stage does the chief ombudsman review your findings, or is it just the lower ombudsmans that just review and give a final? That's just a bit I was a bit confused about.
Yeah, of course, yeah, absolutely. And it can be a little bit confusing, yeah. So our chief ombudsman is a gentleman called Paul McFadden.
Yes.
Normally, so he sits obviously above us all,
Uh-huh.
but more as an organisational figure. So he wouldn't normally get involved in the cases. He would review it if it got to judicial review. I believe he does get involved at that stage.
Yes.
But ultimately, it's just an ombudsman's job to review, a high-level ombudsman job to review the final decision.
Yes.
And that'll be a singular one, yeah.
Yeah. So now that gives me further clarity. So the chief ombudsman, whose name you mentioned, his involvement is only at the stage of judicial review. At the early stages, there are like senior ombudsmans that under him that review the case files.
Yeah, of course. And obviously, if there was any serious complaints or anything like that, then obviously the chief ombudsman would get involved at that stage. Yeah.
Okay. Can I just ask just one last question before we move on? Can I just ask how many ombudsmans are there under the chief ombudsman?
Oh gosh, I'll be honest. I
don't know.
Think I can give you a figure off the top of my head, but
it's fine. It's just for my clarity of understanding. It's not important. So yeah, I mean, I'm satisfied with your role and your organizational structure and the process I need to follow. So I'm finished with that. So can we? I would like to answer your question now regarding my involvement with the solicitor's firm. Would you like me to review what some of the issues are?
Yes, please. So, like I said, from your complaint form that you've submitted to us, there isn't too much detail in that. But the firm have sent across the complaint letter that they've responded to you with, the emails, and I think some meeting notes that they had with you. I think because you complained via telephone a few times as well, didn't you? So
yes.
You've sent some telephone attendance notes across to us. So I've got some idea, but obviously discussing it with you, I'd rather hear it in your
Yeah. Well, I mean, so there's two elements of the complaint. I'll discuss the less serious element of the complaint and the more serious element of the complaint. So it is right. I contacted the solicitors firm at the start of April. They were contacted. The process of contacting them, and I'm based in Bradford, Oldham, West Yorkshire, Lancashire type area, up north. They are based, as you're aware, down south in London. And the reason that it was necessary for me to contact them was that a final hearing had been determined in the Court of Protection regarding my mother, and I was a respondent party, and the case had been. The situation had been left where it became impossible for me to represent myself, because that's what I had previously been doing. Obviously I had been given advice to get legal representation in the court of procedures, which were ongoing from, I believe, December 2018 until obviously when I contacted Berkniazi in April 2021. So there were numerous court cases going on, and I had chosen not to seek legal representation, even though I knew that I could get legal aid. It was a decision that I had made. However, unfortunately, as the final hearing happened in February of 2021, I was left with no practical position to represent myself, so therefore I was forced to take on legal representation, and therefore I proceeded to seek to get a solicitor who specialized in the Court of Protection. I actually approached barristers to start with, because you can get barristers that are like you don't need to have a solicitor. However, the barrister told me that the barrister that I approached, he actually recommended and forwarded my inquiries with them, because he felt it was more appropriate that I should go down, get legal aid, and get a legally aid represented solicitor. So in April, start of April, that's how I ended up with seeking to secure Berkniazi's services. So that's the start of the point. Now, obviously, the relationship, I feel, had broken down, I believe, in May or June time. Hence why I started to raise complaints. But so from my perspective, the relationship had started to deteriorate quite early on. Because from the start of April, when I contacted them, I was obviously, my position at that stage was, because there were still ongoing proceedings, was to secure their services. Because obviously, just because I'm making inquiries with them does not necessarily mean that they are in a position or willing to take on the representation. And obviously, there was an issue of sorting out the legal aid. Now, there was a substantial delay in securing their services. So I don't believe that their services were formally secured until, I think, the next hearing date, which was, I think, around about the 12th of May, which was an issue of concern for me, because it was unnecessary for them to delay securing legal aid to give me a decisive answer. And so that was a point of concern to me, but I anticipated that there was some malevolence from the early stages, because understandably solicitors don't work for free. They need to give me an answer, and if I'm qualified for legal aid, that should have been quickly prioritized. Now there was no definitive answer from them that saying, yes, we are going to take on your case, please fill in the legal aid form and we'll get this, and so therefore we can give you advice. There was a substantial delay, as you can appreciate, or maybe 6 weeks, the whole of April and at the start of May. And I believe that when the solicitor became aware that there was actually a hearing on the 12th of May, at that stage, a day before, he had quickly rushed through the legal aid application form. However, towards the end of April, he had asked me for my financial details, and I had proceeded to provide them, quite swiftly. So my correspondence would quite clearly show that I was acting very promptly, and they were acting very lethargically. And that was a point of concern early on, but I anticipated some malevolence. Because the situation is complex, so hence why I've said that there's two issues that I wanted to discuss with you. One of those is the most serious aspect, which is the aspect I'm talking about judicial malevolence, and the other is the less serious aspect of my complaint, which is because which is to do with disclosure. So some of the complaints, obviously, as you can appreciate, my priority is to deal with this court case that's going on. I've got a legal representative whose services I'm looking to secure. There's been some delay. Eventually, those services are secured. And a couple of months later, the relationship starts to break down. And unbeknown to everybody else, I have like a policy myself when I'm engaging with like third-party organizations, particularly since we started this conversation and you mentioned the Data Protection Act. So ultimately, what I often do is that whenever I engage with any professional organization that I know would be collecting my data, I often, when the relationship ends, I make a subject access request for full disclosure of the case file. So that is normally my policy when dealing with any professional organization. It's not selective. It's not like I was particularly picking out on somebody like this, because I take data protection and the Data Protection Act very seriously. And it's just simply because I come from a software engineering background, so I'm very appreciative of the Data Protection Act. And so often it is not unusual of myself to make subject access requests for full, complete, and comprehensive disclosure of data. Now, I only do that when the relationship has ended normally. However, it was in this particular circumstances, I had anticipated that the relationship was breaking down, so I believe I made a subject access request sometime in May. Just preemptively, because I anticipated that the relationship would be ending soon because of some malevolence that had taken place. And then the firm did not take that subject access seriously and actually provided the limited disclosure. It was not full, complete, and comprehensive as I requested, and they had not taken it seriously. Basically, they had a deadline on the Friday, and they said, "Oh yeah, we'll get around to it over the weekend, and we'll let you know on Monday." And I was like, "Well, this is not acceptable, because obviously, as a solicitor's firm, you are fully aware of the Data Protection Act and the strict time limitations. There's a 1 calendar month." And it's normally my policy when I make a subject access request to seek an acknowledgement from them, and then just to confirm a few days beforehand, just to send a reminder email or correspondence saying that please can you ensure that disclosure does take place. So I'm satisfied that they are not going to be, that the disclosure is going to take place and there's going to be no exemption being applied. Because as you may or may not know, the Data Protection Act does permit you to have a 2-month extension if it's complex. They have not sought an extension of time. They're like basically made the disclosure, and the disclosure, normally it's my policy to ask for both electronic and physical records, because that's a right afforded to me. And it just seems that they had wasted a month in order to take the time and become over the time limit, and then it was all done electronically, and because the solicitors firm have an electronic system, the time effort it would have taken for them to make the disclosure was probably less than 15-20 minutes, but yet they had delayed it until after the time frame and then just provided me with electronic disclosure, which I was not satisfied with. So it's my policy that once I receive the disclosure, I often just confirm that this is everything, and I'm satisfied that the matter is closed with. However, the matter had not been closed with because they had not provided me with everything. They had not provided me with electronic, the physical records, and there was substantial records missing. So I think raised that in an email that, look, I'm missing the telephone recordings, because obviously you had informed me that the calls were being recorded, and so that and the notes that was the first serious issue of complaint, that they had not made disclosure under the Data Protection Act to my subject access request in early June time, May or June, when the relationship had broken down. Now, subsequently, there was a period of time after this, because obviously it became clear to me that the relationship was not going to be successful, and I made it quite clear. I asked the solicitor, I said that, look, would it be a case that you would continue on this case if I didn't want you to be on this case? So basically, I was expressing myself that because I've given you instructions, am I, if I at some stage refuse to instruct you further on the case, or are you in a position to say that you're not willing to take on this case because of professionally being embarrassed? Because I know that's one excuse that sometimes solicitors use. And he said, no, I mean, like, obviously I'm taking your instructions right now. If at any stage you want to withdraw your services, I'm happy to withdraw the case, and so on and so forth. So that was the first element of my like less serious complaint, was the fact that they had not made disclosure in May or June when I had asked them to do so, and what they had made was out of time and was not full, complete, and comprehensive what I asked for. When I had done follow-ups, they had like said, no, they had just basically not taken that aspect seriously. But as you can appreciate, alongside the subject access request, which is normally done from my perspective at the end of the relationship, the case was still ongoing, so I still needed to know where I stood with them, because at some stage, the reason that the relationship broke down is that once I started making some serious allegations regarding the judicial process, and particularly regarding the judiciary, they had then stated that we feel that you lack litigation capacity, which was I understood that to mean that this was an act of malevolence, because evidently I do not lack litigation capacity, and so therefore I felt the most serious aspect of the situation is one where the solicitors, having had me become their client and had taken like money from the legal aid fund, were then not acting in my best interest. But I believe, and I had always known, I think from the beginning, that at some stage there would have been some collusion between my solicitor, who's supposed to be representing me under legal aid, and their collusion with the other parties, which is a local authority that I have had like numerous years of ongoing conflict with. So when they stated that, oh, we feel that you lack litigation capacity, it became apparent to me that there was something untoward and more serious and malevolent taking place. And so hence why I had that element of them stating that I may lack litigation capacity. I understood that as that's an act of malevolence. Hence why I had the fact that I had put in the subject access request early, because I wanted to know whose actually instructions they are taking. So when by end of June that they had failed to make the disclosure, my red flags were flying up. And then what happened is that the solicitor unilaterally had taken directions using legal aid funding in order to carry out a mental capacity assessment for me, which I had not agreed to. And then at the same time, in July, the local authority and the clinical commissioning group had instigated new proceedings on the case in order to get my mother vaccinated. And I had obviously wanted to speak to the solicitor regarding this. And so from a period from July to August, I had rang up or communicated or attempted to engage the solicitor, who was plainly just refusing to engage with me. So from the period of July and August, when in June that they had failed to make disclosure, as my legal representative, who was taking legal aid funding and who was also ongoing court proceedings regarding a new application by the local authority and the CCG to vaccinate my mother, he was refusing to engage with me or speak to me or anything like this. So it was evident to me that... Pardon?
Seriously, so between the July and August, because potentially if that's a complaint point, you said that the firm, they didn't engage back with you. So did you request their help with this application that they just not responded to you?
Yes, what happened was that I was engaging with them fully, because I was saying, well, they've just slided in a new application regarding vaccinating my mother, and you're my legal, I do now have legal representation, so engage with me. He was first saying, the solicitor was first saying that, oh, I'm sorry, I was on holiday, I was not aware of this, and so they wanted to restrict my communications, not on the telephone but through emails and stuff at this stage. All right, because I believe that they received instructions to do so. So I'm telephoning him quite regularly, and he's not answering the phone. He's not looking to get back to me. And then, basically, as you can appreciate, when things are written down, you can say just a few words, as you've explained to me earlier on in my complaint to yourself. It's not very comprehensive. So similarly, in an email, things are not comprehensive and not being addressed. And the reality is that there is no need for them not to engage with me in the telephone engagement. and then forcing me to put things in writing. And I was trying to explain to him, look, this is a very serious issue now. There's the authorities are going to vaccinate my mother, and this is now a separate matter to the previous issue. Because remember, the reason I had contacted them initially or sought legal representation is because the authorities had asked me to vacate the premises, and I could not see my mother. So I needed the solicitor's involvement in order to primarily help me see my own mother. And one of the things that the solicitor should have done, because they were not at the final hearing, I asked them, I said, look, because you were not at the final hearing, it should be incumbent upon yourself. I shouldn't have to tell you this, that you should look to get the transcriptions and fully understand and challenge what. So the purpose of me contacting the solicitor was twofold. And I was very clear about this from the offset. Number one, I would like you to help me see my own mother, all right, which I can't see right now. And number two is that I'd like you to help me appeal the decision that was made in February. All right, so the final hearing took place in February. I did not approach the solicitors or seek legal representation until April. And so his answer was that, I'm sorry, you're out of time. And I said, well, people can, it just seemed to me that, people can make an appeal application outside of time, because you only have like 21 days or 28 days to appeal a decision, and then it comes out of time, and then you need to seek permission. But it just seemed to me that he was unwilling to assist me appeal the decision. He simply said, I've got a barrister, which he selected, and the barrister saying that you're out of time, that's a matter closed with. Now I know, as a layman, that's not the case, that you can always appeal a decision out of time. But that would have required the solicitor, first of all, being familiar with the final hearing that he had not been involved in at the time, which would have meant that he would have required transcriptions. He said, no, there's no legal aid funding for that. So he basically advised me that there was no legal aid funding in order to cover the appeal application that I was requested and required of him, because it was outside of the time frame. Yet in July time, he had made the allegation to the courts and to the parties that I had lacked litigation capacity, and then gone back to the legal aid agency to get more funding in order to get me get a mental capacity assessment done on me. So can you understand that the situation had gone from one place that I've given him instructions, having full capacity to take on his services, with the clear aims and objectives twofold. Number one, that I get to see my own mother. And number two is to assist me in appealing the application, which was a final hearing that I did not even attend. So and there had been draconian restrictions placed upon my life that me or my siblings could not even see our mother. And so therefore, when that had happened, it was I anticipated the solicitor to assist me in order to review the final hearing, which was a 5-day hearing that I did not attend, which had resulted in me being vacated from the premises and the local authority taking charge and control of my mother and restricting my access to her. So I was very clear to what I wanted. However, earlier on, I believe in May, the solicitor with the barrister was saying that I lack litigation capacity because I had made a serious allegation that I feel that the local authority, or I believe and understand that the local authority are privately commissioning out the services of the senior judge. So I said, because now I have legal representation and you're my legally aid represented solicitors, I am asking you for legal advice. And the legal advice is simply this: I want you to tell me legally what my options are when I believe that there's judicial fraud taking place and that the judge in this case has had his services privately commissioned out unlawfully by the local authority. In response to this advice, that what I got back was that there's nothing, we can't advise you on that, but because you're making this serious allegation, we think that you lack litigation capacity. That seems nonsensical to me. And then the solicitor proceeded to secure further legal aid funding, not to assist me with the appeal or help me see my mother, but to get more money in order to carry out a mental capacity assessment. And so the solicitors, it seemed evident to me that the solicitors were equally acting with malevolence and their services had been privately commissioned. But can you understand, that is a very difficult thing for somebody to approve or establish, especially as a client. But it seemed that their conduct and behavior was on this par. So come September time, the solicitor has managed to secure the services using legal aid funding to carry out a mental capacity assessment in my absence. All right, so I'm not even involved. I'm not even involved in the mental capacity assessment, and the mental capacity assessment has concluded that I lack litigation capacity based on reviewing some videos that I had forwarded onto my solicitor. So I had, in the course of them seeking of them representing me, I had forwarded them a substantial amount of information because they had not been aware of the court case that had been going on for several years, and they had not attended the final hearing. They obviously were involved after the event. So it was important for me to spend a lot of time and resources in order to speak to the solicitors and forward to them a substantial amount of documents. All right, and that included video evidence. I had a YouTube channel that I had a YouTube channel that I operated on behalf of my mother. Just to clarify, I have a YouTube channel in the name of my mother that I have uploaded videos and would often use those videos in order to relay information into the court or the other parties. Now, what had actually happened in this circumstances is that the solicitor got caught out because the YouTube channel that I had given him, he had forwarded a different YouTube channel to the instructed mental capacity assessor. So when he basically got caught because he should not have had access to this second YouTube channel that I operated in my own capacity. He had unfortunately, or fortunately for me, forwarded on the wrong YouTube channel details. And because he had done that, it became evident to me that the mental capacity assessor, could technically not have had access to this secondary YouTube channel because my solicitor did not have access to this YouTube channel. However, the local authority did. So when I tried to challenge the solicitor that exactly how did this happen, how did this information get to the assessor, he was being very vague and abstract and being very very dismissive. However, what both the solicitor and I knew that the last hearing that we had attended, which was in May, as I explained to you, I took on his services in April. There was a hearing in May. There was going to be a further hearing at the 2nd of October 2021, and so obviously he was still as my retained services in September. Before this hearing in October, I told him that at this stage I'm withdrawing your services. I'm making it quite clear I do not want you to represent me. And so then the penny finally dropped. He said, "Ha, you can't drop me because I now have evidence that you lack litigation capacity." So I now found myself in this unique situation where I had taken on the services of this solicitor. He had made false allegations that I lack litigation capacity through the collusion with the other parties, all right, because obviously it was in the interest of the prosecutors or the other party to say that this person lacks litigation capacity, so he's never going to be in a position to take any legal action against anybody. So at this stage in September, it comes to my attention, the penny finally drops of why these allegations were being made about my lacking mental capacity or lacking litigation capacity in May, that both the barrister and the solicitor had themselves unilaterally concluded. Hence the relationship had broken down, because they then were in a situation in September where they no longer needed to take my instructions. I no longer was in a position to give them instructions. I was no longer in a position to even withdraw the services. And so therefore, I said, I'm not happy with this. And so, but the priority, as you can appreciate, was for me to prepare for the hearing that came on the 2nd of October. Yeah. Are you with me so far?
Yeah. I've got a few questions, but I'll let you finish with the thing, then we'll go back to them.
Okay, so in the 2nd of October, remember, in the 2nd of October, there had been no application at the hearing of May regarding the vaccination issue. The vaccination application had happened in July, when the solicitor had not chosen to represent me or have any engagement with me. So now, at the hearing on the 2nd of October, the solicitor are, basically saying we're representing him, but yet they're not willing to address the vaccination question, because the vaccination question had arisen in July by the CCG. They had given me absolutely no advice, no assistance regarding the CCG application. What the hearing on the 2nd of October was for was for, I think there was proceedings of penal notices, or they were going to try to put me into prison. So that's what the hearing of the 2nd of October was. What both the solicitors and my understanding were when this hearing was originally listed in May. So in May the hearing was listed in May for two purposes. One was to review the care package that my mother had been receiving subsequently to my discharge from the premises, and secondly, they wanted to obviously see how they could progress the penal notice, which they said that the injunction orders that they were saying that I had broken. So that's what in May. That's what the solicitors and my understanding was, that the 2nd of October was going to be a hearing to review both how the care package in place for my mother is going, and number two, how how to proceed on the penal notice injunction violation. All right, would there be a final hearing for that? But then, as I explained, in July, August, the CCG had sneaked in a vaccination application, which was also heard on the day. Yet, on that particular day, on the 2nd of October, the solicitors were in court, but had not engaged with me, because they're saying we don't need to engage with you any further, because we now have evidence that you lack litigation capacity to give us any instructions, and we don't need to give you any advice. So therefore I found myself on the 2nd of October in a position where I am formally legally represented through a legal aid solicitor. However, both the solicitor and barrister are not talking to me, are not engaging with me, and now I have to in person defend a CCG application to vaccinate my mother. So I do that quite well myself. However, because I believe the judge's services are privately commissioned, that aspect is simply railroaded through. But one thing I did ask of the judge was, I did say I would like to seek permission to appeal the decision to vaccinate my mother. And so once that had concluded, the 2nd of October hearing had concluded, I then, obviously forcibly said that to the solicitor, look, I don't want you to represent me any further. You don't act on my behalf, even though I told you in September that you don't. You've still come into court, and now you continue to represent me. And at this stage, they're saying, well, no, the matter is no longer, you no longer are in a position to give us any instructions. We are now taking instructions from the official solicitor. So what had happened in October, at the hearing in October, the solicitors and barristers had attended because they wanted a finding that I lack litigation capacity. And so therefore, in the 2nd of October, there were just so many other, there were so many other things that I had to defend. One of the things that my solicitors, was saying that he lacks litigation capacity. And because if I lack litigation capacity, they now need to take some instructions from somebody else, need to act on my behalf. So that's the role of the official solicitor. So then what happened in October to November, the solicitors were saying that we've actually applied to the official solicitor, and now we're taking only instructions from them. So then at this stage, I make a second request for full disclosure, because as far as I'm concerned, I don't want them to represent me. I do not agree with the conclusion that I lack litigation capacity, and I tell them I don't want your involvement anymore, and I'm going to start the appeal process myself regarding the vaccination, forcibly vaccinating my mother. The solicitors then coming back to me and saying, oh no, you got legal aid funding, please forward your application to me so I can then forward it on to the official solicitor so they can make the decision. I said, no, I'm not going to do that. I don't want your involvement. What I want you to do now is that in November or October, November, after that hearing of the 2nd of October, what I want from now is that as far as I'm concerned, you do not represent me, and I want my case file now. So I make a second access for subject access disclosure. Yet, as far as I'm concerned, the relationship has ended. As far as they are concerned, the relationship is not ended, because they're still getting public money, and they've now got somebody to give them the instructions, which is the official solicitor. But as far as I'm concerned, the relationship, I'm looking to disengage the relationship. I do not want to give them further instructions. I want to end the relationship. Hence why I make a second request. And the second request is the subject access request is once again delayed for a month, and then they told us, nah, we don't want to give you disclosure because you've already had disclosure, all right, in June. So this is like they've given me some excuse and refused to give me disclosure. However, I understood that they're still representing me and they're still basically doing work under legal aid. So, and then obviously in December time, I believe in December, I telephoned them nearly every single day and left them messages. They would refuse to answer my messages or engage with me even in December when they're saying that we still represent you. I said, okay then, if you're, I don't want you to represent me, but if you're still representing me, then come and speak to me, because obviously my main concern is that my mum's going to be vaccinated. That's not why I contacted you. I contacted you to gain access to my own mother, and now all of a sudden she's going to be vaccinated. It's not something that I think is appropriate, and so I'm ringing them up. I'm obviously raising concerns or raising complaints to them, saying, and I think that's when I formally started complaining, raised a formal complaint. Because remember, back in May June, I had simply asked for a disclosure which they had failed to comply with. Once they had failed to comply the second subject access request in November, I then raised a formal complaint in November, which I believe that you now may have a copy of. But yet they were still representing me. And yet they were saying to me that, oh, you know, the official solicitor's now on board and you should come on, liaise with, give us information, and we will then take legal aid funding to put the appeal in. I said, no, we won't be doing that. So anyway, I had then independently put in an appeal application for the vaccination question, which was accepted, and I made other parties aware that, look, this solicitor no longer represents me, and I'm going to be appealing this process myself. However, all the other parties were simply just ignoring what I was saying, and because everything had, all the pieces had been put in place where they could exploit my legal aid funding for their benefit, to their advantage, rather than for my benefit and to me and my family's advantage. So these things were still ongoing. Come Christmas time, the hearing on the 2nd of December had stated that I can have permission to appeal the vaccination order, and also I had then subsequently asked for transcriptions, and those transcriptions were agreed that would be provided to me. But come December time, or several months later, I had still not received those transcriptions, and I had still not received the orders, the drafted sealed orders by December time. So I was liaising with my solicitor, who's saying that he represents me, saying, look, where are the transcriptions? I need the transcriptions of the hearing. I need the order, the sealed order, so my appeal application can proceed, and I can give grounds for appealing the orders, especially regarding the vaccine question. Then I was told, no, I was not told, I was subsequently made aware in January 2022 that a further hearing had taken place without my involvement, without me being represented, without my awareness, where the judge had ordered the second vaccine to be given to my mother. Through no input on my own. Remember, in October, the judge had ordered my mother to be vaccinated. She was vaccinated in November time, or in October, November time, quite quickly. And I hadn't even had an opportunity to put through the appeal or stay the proceedings. They was just railroaded through to vaccinate my mother. Then I think start of January, 10th of January, another court hearing had taken place without my involvement, without me being aware, without my consultation, where the solicitor had put in an application for her to be given the second vaccine. Within days of that order and me being made aware, and the judge ordering that a further mental capacity assessment needs to be carried out on myself, because the first mental capacity assessment was carried out to my exclusion and absence. And so what happened was that come January 2022, the solicitors, in collaboration with the judiciary and the other party and the local authorities and all the other parties, were basically trying to railroad me and forcibly trying to get me to have a mental capacity assessment whose outcome they had already achieved, which was that I lacked litigation capacity. And that was what had been ordered by the solicitors. So that's what their priority was, that even though that they had got the official solicitor on board, the official solicitor was not satisfied on the mental capacity assessment, because the mental capacity assessment of September 2021 had been done in my absence. So basically, everybody just wanted to tick their boxes to ensure that they have like a mental capacity assessment stating that I lack litigation capacity, to justify all the actions that have been taken place by the solicitor and everybody else. So that's what was ordered at the start of January. What was also ordered was to give my mother a booster or second vaccine. Within days of receiving that vaccine, my mother was dead. All right. So my mother died within days of receiving that vaccine. which I had been protesting all along. So then I obviously made a second. I made it clear to the solicitors that they had been a party to the joint enterprise murder of my mother, which had been the issue from day one. And so this is the lesser complaint I have is focused in on them failing to make disclosure to me. All right, which obviously by January time my mother had been murdered or dead, as far as I said. I made the allegation both to the local authorities, to the solicitor, that this was a deliberate attempt to murder my mother. And so the solicitors were aware of this. Now, what had happened in January, the case effectively had been ended, not through the solicitor, not through my efforts, not through the efforts of the solicitor and the other parties. The case had ended because my mother had simply died. All right. So at this stage, now that my mother's dead and the solicitor recognizes that they effectively cannot represent me, and the even though that their intentions were to continue to represent me through the official solicitor, the matter is effectively now coming to an end. And so therefore I make a further attempt to get now that they even themselves recognize that they do not represent me. So therefore I once again instigate my policy of saying, well, now because my mother's dead, all right, you are no longer going to get any more legal aid funding. Now make disclosure to me. And one of the things I want to know is I want full disclosure of how much money you've made through this. I want to know all the case file. I want to know your engagement as a data controller contacting third parties. I want to know how you managed to secure the services of this assessor. I want to know which other parties you got involved with. Because obviously, if I'm making the very, very serious allegations that, number one, the local authority are privately commissioning out the senior judiciary. Number two, that my mother's been murdered. That evidence is not done like as a private individual. It's done through formal processes, through people that are in a formal capacity, writing things down under the Data Protection Act, which is all being recorded. So when I had said, all right, well, fair enough, at this stage, you'd no longer represent me. I want my case file. And so therefore, that was the third attempt. The first attempt to get my full disclosure was in June 2021, which was partial disclosure. The second attempt was in November when I felt the relationship had ended. That was failed upon. And then the third and final subject access request was, I believe, February, March time, that I said, look, my mother's now died in January. Give me my case file. And so therefore, even to this day, they're refusing to disclose, make a full subject access disclosure. So I said, according to the Data Protection Act, the maximum penalty permitted in law for me, which I will be prosecuting you upon, is 20 million euros. So I then proceeded to advise them that I'm going to take litigation action against you, because I believe that not only are you acting fraudulently, but that you have deliberately on several occasions failed to make subject access disclosure. I've then proceeded to elevate that to the Information Commissioner's Office, which is normally my policy. When people don't comply with the Data Protection Act, I usually slap in a 20 million euro invoice and then have the matter investigated by the Information Commissioner's Office. And so that's what I normally do. That's my normal policy. So I proceeded to do that, and expecting. I mean, like I said, that's a different avenue that I don't need to go further into. The matter was raised with the Information Commissioner's Office. That look, they are refusing to comply with my rights for disclosure. So as it stands today, we're now in January 2023. All I really wanted, so this is the lower serious aspect of my complaint, is that all I want is a full, complete and comprehensive disclosure of any and all data that they've collected regarding this case file from myself. That includes emails, telephone calls, case notes. It also includes any third party that they've contacted, because as a solicitor's firm, once they contact a third party, such as, for example, an assessor or anybody else to act as an expert witness, they are effectively still the data controller. So any information being departed to a third party, such as an expert witness, that information should also be disclosed to me. So just to summarize, the less serious complaint with Berkeley Aziz is that to date, they are not giving me full, complete and comprehensive disclosure of my case file. And I'm not really too concerned about that, because when the opportunity arises and I do take litigation action against them, under civil procedure rules, they have to make that disclosure. So I think it's nonsensical on their part to not comply with the law and to not provide me with that disclosure. So the lesser point that coming to yourself now is that one of the outcomes that I would like to achieve through your involvement is basically helping me to secure my case file and data to have a full, complete, comprehensive disclosure to my satisfaction, not partial disclosure where they say, like, we made some disclosure and we've ticked that box off. It needs to be to my satisfaction, where all questions, like if there's documents missing or if there's anything I have concerns about, that they should fully relate me all those issues and address all my questions. So that is one outcome that I'm looking to seek from your involvement as the Ombudsman, recognizing that there is a Data Protection Act, recognizing that I as a client do have a right to have access to my data in law, and the fact that this has not been provided to me. And so one of the things that I would like you to, as part of your investigation, to look into is the aspects of the three separate subject access requests. Now I understand that that is not your remit, because that's more to be done with the Information Commissioner's Office. But irrespective, it does show that there's been a systemic failure of the solicitors firm, who are a legal firm who specialize in the law, and that they have violated the Data Protection Act. Because the other allegation, the other aspect of the law that I've made the solicitors aware of is the Fraud Act 2006, Section 3 says that if there's a duty of care on an organization not to disclose information, which I believe I do have that right, and they fail to make that disclosure, then there's a statutory violation of the Fraud Act 2006, stating the fact that failure to make disclosure when you have a duty to do is a violation of the law. Now I'm quite, as you can appreciate by speaking to me, you can see that I have some rudimentary understanding of the law, hence why they were trying to state that I lack litigation capacity and I don't know about the law. I obviously do know about certain sections of the law, particularly the Data Protection Act, which I classify myself as an unauthorized expert at, but obviously the Fraud Act as well. So I made the solicitors have been fully made aware that I intend as a consequence of their failure to take action against them, and one of those is fraud, because if I have a duty of care, if you have a duty of care to disclose that information and you don't do so, that's clearly black and white in law, that's fraud. And so they are fully aware of this. Sorry?
So you mentioned that you have reported this to the Information Commissioner's Office.
Yes.
So they're currently dealing with this, are they?
Well, yeah, those inquiries are still ongoing with them, because obviously there's been some issues. So just to make you aware that there are other parties that I've contacted before contacting you. So one of those parties is the Information Commissioner's Office regarding Burke Niazi solicitors. Or the other party that I've contacted, which I've recently forwarded to you, was I had lodged in September or October, I lodged a formal complaint with the Greater Manchester Police, because obviously this leads me to the second most serious aspect of my complaint. So just to clarify, the less serious complaint which I'm asking you to look into is more focused in on the duties of the solicitors firm to deal with aspects of disclosure. Now, obviously, there's a overrun on what your investigation is and what the Information Commissioner's investigation would be. But your focus should be on the solicitors. The legal aspect, not so much the focus of the Data Protection Act. Does that kind of make sense? Yeah. So the reason that I've raised this as a complaint is that obviously for you to have look at it from the solicitor's perspective, that look, as a solicitor's firm, you're a public notaries, you're regulated by the solicitors ombudsman or solicitor regulatory authority. You have a certain duty of care. Now, if your client has made a request, how was that request fulfilled? Because that's part of the complaint that I raised, in addition to the most serious aspect of the complaint. So I just wanted to take a little break here just to ensure that you do understand the lesser complaint or the less seriousness of the complaint, which is focused in on the disclosure of the case file, and the outcome and my expectations are to look into this aspect and to determine that whether I'm in the right or whether they're in the right, not have disclosed this information. And that seems to kind of be a very serious, straightforward kind of aspect, isn't it? If I made a request, there's a law, I did it under the law, I made it under the Data Protection Act, there's statutory limitations of when that should be complied with. Was it complied with? If it wasn't complied with, why is your client complaining to the Ombudsman that this was not complied with? And that's something that you can be looked into. So I just wanted to finish off on the lesser complaint, before I start on the Sadie's complaint.
Okay, so let me just go through that, because obviously you've given a lot of information. I've been making notes as we've gone along. So really our role as a legal ombudsman is to look at service complaints. So there's a few things that you've mentioned that I can see you've also, you emailed the firm about, you spoke to the firm about, that we can potentially investigate. But in terms of anything to do with data protection
Yes.
and your subject access request, I was going to say to you that you need to go to the Information Commission for, which you've already done. Now,
Sorry to interrupt you. I'm sorry to interject, but yes, what I clarified is that I've gone to the Information Commissioner's office. What aspect I would like you to look at is not from the Data Protection Act, but like you said, from the Service Act, service perspective, because that's still a service, isn't it? That they have to comply with the law. So that's what aspect I would like you to not to look at it from the Data Protection Act, which I'm sure you would not be familiar with, but the Information Commissioner's office is specializing in. But just look at it from the service perspective. I just wanted to put that caveat in there.
So so for example, okay, but in terms of service, you've asked for a subject access request. They have given you some documentation, but you believe that there is a lot more documentation that they haven't shared with you. Is that right?
Well, as I explained, the documentation, the quick question is that when was that request made, which request am I referring to, and what documentation was provided? As I've explained, that the documentation that they're saying that the service has been dealt with was done in June or May or June. So obviously that I made a final subject access request after the services had ended. So that was done this year, in 2022. So that's not been complied with.
Okay, when did you make that request?
So just to clarify, I made the first subject access request in May, June. I made the second subject access request in November. I made the third subject access request in, I think, February or March 2022.
Okay, so they responded to your first one, but not your second and third one.
Well, what they've done is not just responded, they've actually made partial disclosure on the first one. Because remember, this was, I think, a month and a half into, or 2 months into their service, because they are taking on their services in April. The second subject access request was denied, and so was the third one. So they have not made disclosure. And remember, this is the most important one is the last one, which was made in February, March 2022, because that's when ordinarily a subject access should take place, when the service has ended. So the question is that after the service had formally ended, namely after my mother had died and the case had ended, what disclosure did they make? And they haven't made disclosure.
You mentioned there that they denied the request. So what did they actually say to you to deny the request?
So the first request they had run out of time. The second one they said that it was, because as you can appreciate, in the Data Protection Act there are exemptions. One of those exemptions are I think I can't remember the top of my head, but if you make malicious requests, or repetitive requests. All right, so they had used a data protection exemption, which I don't think applies. They're saying it does. They're saying that so they found basically a pretext saying that we've already made disclosure, but that doesn't make sense because you're still providing the service, and there were other. So I said so in November I said, well, from your last disclosure to today in November, there's further work that you've done. Give me that information, and so they basically fobbed me off in essence. So then I said, okay, I'm not really bothered because at this stage I've got other things going on. But when the case had formally ended, so obviously the case had ended when my mother died in January. So then I said, at this stage I'm making a subject access request, which was I think in February or March, because what I wanted to know is, I look, it's quite simple. If I'm a private client, I know how much money they made. As a legally aid funded client, I still need to know how much of my legal aid money that they've taken. So all I want to know is, I said to them, look, provide me with a full disclosure, especially your costs, because you're a solicitor's firm, you got legal aid funding. I want to know how much money you've made. All right, because obviously what happens is that, as I'm sure you're fully familiar with, once a solicitor's firm has finished with the client, especially with legal aid, then they draft the costs, and I obviously wanted to have a copy of that costs. So to date, I think as a client, as as a service provider and as a client, very basically, I need to know how much it's cost, how much the service has cost. So I would have expected and anticipated a comprehensive breakdown, which they themselves would have had to provide to the legal aid agency in order to get the money. So to this date, I don't have that. And I think as an aspect of service, if I go to any organization that's that I'm paying privately for, so it doesn't really make a difference whether I'm a private client paying from my own pocket, or whether I'm because of my circumstances I'm a legal aid funded client. Is irrelevant. There has to be an element of transparency of how much has the service cost. So you would expect that if I've made a subject access request or request in my file at this stage, several months after the service has ended and I've raised a complaint, is that one aspect I should know about. I should know how much money the Burke and Niazi solicitors have made through my legal aid funding, and I don't know that information. And I've asked for that.
You said that they denied it. What did they explain that? So did they not respond, or did they deny the request?
They did respond. One of the excuses that they made was that, we've not actually. So I think it was February, March time that they said that they've still not got around to finishing off the costing. All right. So that was one of the delays, because obviously I made it quite clear to the solicitors firm, this has all been done for money, and I want to know how much money you've made through my legal aid funding. So I personally don't view it as somebody else's money. It's still my money. It's basically got in my name, and you've basically been operating, using my details. So basically, I feel one of the issues that I have with them, that they basically use me as a benefit mule in order to take extra money out of my legal aid entitlement. So irrespective, the whatever allegations or assertions I make, one of the key factors is that as your client, I need to know, as a solicitor's firm, how much money did you make? And I don't know that. All right. And one of the ways I've approached that is to make a subject access request, which, as you can see from the correspondence, is they have obviously done everything in writing. And they've made some excuse initially that we can provide some disclosure, but we can't provide the costing because we've not done the costing. And then eventually they said, no, we're not going to provide you with anything because we think that you're a vexatious requester, or used to use an exemption in order to get out of that. But irrespective of the Data Protection Act, which obviously, like I said, you're not in a position to look into, I just generally speaking, if I'm a client and I'm paying for us and I'm getting a service, and that service is being paid for whether directly by me or whether indirectly by my entitlement to legal aid, I, as a client, would like to know how much money you've made. It's a simple question that I need to have an answer to, and that I'm not in a position to have that quite clarity of understanding. So you can quite clearly see that is one outcome, that approaching yourself, I think that's only a reasonable thing for me to ask. Like, there has to be a level of transparency which is not taking place. Hence why, obviously I made the subject access request, because I believe, and this is coming to the second part, which is more serious, is that there's been clear collusion by the solicitors firm to my detriment. But focusing in on the subject access request, that's one of the reasons I made a subject access request. I want to know, and you're entitled, the solicitors firm, I would believe, as a service delivery, would need to just tell me, look, at the end of the day, why should I be discriminated against because I'm legally aid funded compared to a private citizen? Because if I had given private instructions to the solicitors firm, they would have invoiced me and I would have known how much money they have made effectively, all right, or for their services. I don't have the answer, and so that's one of the reasons that I would like clarity of understanding to know how much money that they made. And I think, objectively speaking, that's a very fair assessment, that I should know how much money you've made. And if I've made several subject access requests and you've not provided me with that information, well, you need to provide me with that information, because alternatively I can get that information by making a subject access request to the legal aid agency, or I can make that subject access request to the official solicitor who got involved in this case. But in the first instance, all right, I need to go to the solicitors and say to them, look, these are the aspects of my complaint. In addition to you not representing me properly, and you're working with the other side or whatever other things. One of the things is that, like you said, like in this conversation today, you've told me that they've disclosed quite a lot of information to you. No doubt they have done so, but they've not disclosed that information to me. So why? And one of the reasons that I make a subject access request at any stage in any proceedings or any situation, I should have the most information because I'm the client or I'm the party that's involved in the case. So when I don't have all that information at hand, I obviously jump to the conclusion that there's some sort of deliberate malevolence in place. So if you, like you said, I have given you very limited information, however, they have given you quite a lot of information, and obviously at some stage, and just for your reference, at some stage I will be making a subject access request for this case investigation because that's just part of my policy. Because at least that way I will get some information. Because the worst aspect is that when you're put into a situation where other people, I mean, this is clearly a deprivation of liberty. Just imagine this, that other people are making decisions on your behalf that have a detrimental effect upon you that you have no involvement in and they have no engagement in. So this is one of the serious aspects that the solicitors had no engagement with me, but yet were formally representing me and and railroading an aspect to my detriment. But the lesser issue, which obviously I'm going to stop now and let you seek your clarity on, is simply focusing in on disclosure.
Yeah, and I understand what you say. Have you spoken to legal aid at all to request anything?
Not at this moment in time, no, because there are other priorities that I have ongoing. But it will be my intention to, obviously, no, actually, yeah, that will be my intention at some stage. But that information is not going anywhere at this moment in time. The primary source is the solicitor's firm.
Yeah, and I understand that. I mean, in terms of your complaint here, you want us to try and obtain, copies of documents, etc., to see if we can do this for you. In terms of data protection, the issue we've got is, we can ask them and say, Mr. Hussein's willing to try and resolve this complaint by, disclosing this information to him. They can disclose it, but if you don't believe that's full disclosure, if you think again that they're just doing partial disclosure, or they come back to us and say we're not disclosing it under this rule of the Data Protection Act, then
Sorry, go on.
Then that is something that you're on the right track with in going to the Information Commissioner's office. We can't instruct them to release everything. If they release, 6 documents and say that's, or they say, we've already released to him, the first time we've released all the documents, we have no way to prove that's partial or not. We can't
that's fine.
enforce them to share information.
And I would not anticipate that from yourself, but you can understand, just speaking objectively, if I'm saying, look, they're not giving me my documents, and they're saying yes, we have, and then the question that you can ask is when and how did you give the information? They're going to say, well, we provided this information. They'll have dates, won't they? So we provided this information on this particular date. So then the next question you have to say is that, well, were those provided electronically or physically? They will tell you that we provided them physically. So then electronically. And so then the next question you can ask them, well, considering that you've already collected all this information and what you're saying is that you've provided this information to him, would it be possible for you to now accepting the fact that there was some information provided, like for example the costing, was that provided? Can you evidence that? Was your costing provided? What date did you draw up your costing? All right, and they'll tell you, well, at this stage, well, was that provided to the client? Well, no, it wasn't. Okay, so considering that you've already done all this work, would it be too unreasonable for you for us to now, considering that with the Ombudsman and a complaint has been lodged with us, would it be possible for you to give that information both in electronic and hard copy, all right, because it's not going to be problematic for you because you've already gathered all this information, and then at least we have it on evidence that at least at this particular date, irrespective of what Mr. Hussein is alleging that was provided or not provided, at least at this stage, as a way forward to resolve the partial of the complaint regarding disclosure, would that be unreasonable? Now they can say, you're right, they can turn around and say, no, we're not going to provide it, and there's nothing you, the Ombudsman, can do about it. I understand that, but at least it shows that, gives them the opportunity to resolve this issue, which puts me in a better standing, which I can say, look, all I wanted was part of my complaint was just getting my information. If it was so readily available, and obviously I think they tried to pull the cost card. They tried to say that you need to pay me us money, and now under the Data Protection Act, I don't need to pay anybody any money. I know this for a fact, and often what organizations do, because the Data Protection Act subject access request is a cost to the organization, which is not being remunerated because the law states that you should not be charging for this. Often what organizations, in my experience, try to do is they try to worm their way around it by saying, no, actually, we've already given you this information. In order to give this information, we're going to charge you £50 or more. So, that is like one of the problems I've had, I think, with this firm as well. But I think that's a reasonable way to, that would be like, it's always aspect of being reasonable, isn't it? I'm coming to you and saying, look, this organization is acting unreasonably. One of the reasons that they're acting unreasonably is that they're not providing me with my information, which was the reason that they, came into, are in business anyway, which they've been paid for, and it's my information. All that's a very reasonable aspect. Now, if the organization, solicitors firm say to you that no, he's acting it's all an aspect of reasonableness, isn't it? Now, if I don't think I'm not acting unreasonably. If they're saying no, we don't want to provide the information because of this exemption, or it's going to cost us. Now, if they say that no, we're not prepared to provide the information unless he pays us, then obviously you could say to us, look, hey man, we can't do anymore. They want money out of you. I can then take that and say, well, actually, I can take over now. I can say, you can't charge me because of this legislation and stuff. But at this stage, I think one of the aspects, and it's quite a reasonable aspect, is that, look, if you're a solicitor's firm, you're regulated by the authorities, regulated by the Solicitors Regulatory Authority, and this is your client, and you've already got paid. It's not the case. Sometimes what solicitors do is that we're not going to give you the case file because we've not got paid. All right. So unless you pay us what we're owed, we're not going to give you the file, and that's also reasonable, isn't it? If the client is not paying them, yep. But
so what information do you think you should have received from them? So information on your costs.
Okay, so
you believe you should have a breakdown of costs.
Okay. So under this, like as I've explained, I make numerous requests. One of the exemptions in the Data Protection Act is that repetitive malicious applications. So in order to avoid this, I have a simple policy. I require full, complete, and comprehensive disclosure of any and all data that you hold about me. That's it. That statement I obviously as a caveat put in there. So that saves me time from picking things out, or them saying, well, actually you didn't ask for this particular thing or that particular thing. So the data that I require is full, complete, and comprehensive any and all data and information that you hold about me. All right. So that's the caveat I have. All right, and so they can say, well, that could be too costly for us, and we've already provided some information. But like I said, if some information's been provided previously, it's been already collated, and so there's no cost involved. So just to clarify the question that you asked me, what information do I want? I want full, complete, and comprehensive any and all data.
So in terms of the complaints that we put forward for you that you would agree to, like I said, they have to be broken down into specific aspects.
Mm-hmm.
If the complaint was that the firm did not share a cost breakdown with you, that is a complaint, okay? But if it's that the firm, didn't respond to your subject access request, they did respond, but obviously saying that they weren't going to share it. If the complaint is that, the firm didn't share all comprehensive information with Mr. Hussain, that's not a complaint we can deal with, because then it would come down to whether our determination that all the information they've shared with you is correct, and that's not something that we can look at. Because how can we know as legal ombudsman whether the information they've shared with you or not shared with you is the full comprehensive information? I'm
not asking to make that determination. What I'm asking from yourself is to have that established from the other party, just as a statement stating the fact that all information that Mr. Hussain has requested has been provided to him. That's it. Like if they make that statement that, look, yeah, all the information that he's requested, we have no further information to give him. He already has that information. All right. Then obviously,
I can put it forward, Mr. Hussain, that part of this complaint, your resolution is that you want the firm to provide you with all comprehensive information that you've requested.
Yes. That's it.
I can put that, but
yes.
What we need to determine is what the actual complaint is. I can't just go to the firm and say, Mr. Hussain has a complaint, this is what he wants to resolve it. We have to understand what the complaints are as well. So you've made some other points that could be complaints that we can look into. So you made a complaint that the firm didn't make a legal aid application until May 2021, which was 6 weeks after you started to instruct them. That is a specific complaint that we can investigate.
Okay, all right.
Does that make sense?
Yeah, that makes perfect sense. But I think I've been quite clear that the complaint is their non-compliance to their service, which is part of the service is to provide me with transparency. Do you agree that The part of their service delivery is transparency. In order to ensure transparency, they have. If I make a request for something, or if I or so another thing is if I ask them a specific question and they don't answer that question, that would you agree with me that that is a failure of service? So if I ask them a specific, if I send them an email and I say, look, can you please answer this question to me, and then they don't answer that question and they just ignore that question, would that be grounds for a complaint to yourself?
A reasonable service that we would deem, and like I said, we'll send this out in writing. The reasonable service is that they try and answer your questions. If they cannot give you an answer, then they must explain why, or they have to tell you why. For example, with this information request, you told me that they did respond to you, but they responded to say that they weren't going to share the information because of, I think you mentioned malicious or repetitive request, something to do with that. So they've answered the question. It's just that obviously.
Yes. Okay, so look, just for my clarity of understanding, if I ask them a question and I put it in writing, and yes, they can either they can do one of three things, can't they? They can either answer the question, it may be not to my satisfaction, but they've answered the question. That's not a complaint.
Yeah.
They can either choose to refuse to answer the question. They can say, look, we're not going to answer this question. But so that's not, they've refused to answer the question. However, they have a third option by not responding to the question, simply just ignoring it. That would be grounds for complaint, wouldn't it?
Because that comes down to communication. If they ignore your contact without any acknowledgement, that is grounds for a complaint. That's what we would consider an unreasonable service. So if your complaint is that the firm didn't respond to your subject access request, that's a complaint we can look at, because the failure in service there is the communication.
Okay, all right. Look, so I understand this. So, like I said, though that is a separate aspect. The first aspect I wanted to speak to you regarding is regarding the fact that I don't have. I would think as an aspect of service delivery that if the client, as I explained to yourself, like I gave you a quite clear example that as the client, I need to know how much money they've made, all right? And if I've asked that question of them, and they said we can't tell you at this stage because we're still writing up the costs, and then I've made a subject access request and they have said like we're not dealing with this because of the subject access because of this exemption, that's fair enough. But it is, as I explained, it's all about being reasonable about expectations about service delivery. Now if I'm now saying that I'm now in a position where I don't know this information, they've not provided me with this information. One of the vehicles of them providing me with this information is through making a subject access request. And I've done that, and they may have found a convoluted exemption, but it does not negate from the fact that I still do not have this information. So that is the aspect of the complaint, is that the aspect is the aspect of the complaint is that I would require transparency, openness and transparency. And that is that's more of an abstract term, isn't it? I require transparency. One of that, and so your aspect would be that what has this solicitor's firm done in order to be transparent, because that is an expectation of service delivery. One of the aspects also of service delivery is not acting with malevolence. All right. Now, obviously, you cannot make a judgment on that, but that is something that is an aspect of complaint, isn't it? That, look, I believe that's the second aspect, that the solicitors have been acting with malevolence. Now, for example, when you're telling me earlier it took 6 weeks for them to take legal aid, get legal aid funding. Now, the question here, which obviously you're not going to be in a position to answer, based on the fact that is factually correct, that they did not provide you with legal aid retention 6 weeks later, or they didn't make the application in time. The question I need to ask, or I need to understand, is this an aspect of malevolence, or is this simply a mistake? Because often what happens is that people can make mistakes, and mistakes are forgivable because we're all humans and we all make mistakes. So the fundamental aspect, like the broad thing that I'm trying to understand, and the reason for my complaint, is that often when, obviously, as a complaint investigator, you need to understand that is this complaint, the basis of the complaint, is it malevolent? All right, is there an aspect of malice? Because so one of two things can happen. So, for example, let's just take this for example, the legal aid certificate. It could have simply been the case that the solicitors were busy with other things. There could have been, somebody could have left the organization. There could have been a plethora of other reasons. But those reasons now need to be determined, because quite clearly 6 weeks is unreasonable to get a legal aid. So, a response needs to be provided to them. My aspect, and I want to be clear upon this, is that I believe that malevolence has taken place. Now, nobody's going to admit to malevolence, are they? Nobody's going to put up their hands up and say, yes, we were acting with racism. Yes, we were acting with prejudice. Yes, we were acting fraudulently. Nobody in their right mind would make themselves culpable to a criminal act. So what often people do is people often say, no, we were not acting with malevolence. We were acting within our remit. We were acting within the law. So that's the fundamental argument. Because obviously I'm dissatisfied with what's happened, and hence why I wouldn't have raised a complaint in the first instance. The outcome of the complaint could be one of two things. One of it is there was just simply a failure. Now, if there was simply a failure, right, that can be resolved like from a third party. So for example, if one of the solicitors had been racist towards me or used racist slurs against me and stuff, you could have investigated that, determined that, said, well, one of the outcomes we can do is that maybe send that person on customer service training, maybe lacks training, and so that's a resolution. So when things are without malice done by mistakes, those that can be resolved with. However, you cannot resolve something when there's the deliberate intention of malice. Hence why my overriding complaint is that these people have been acting fraudulently with malice. All right. Now I can't prove that, but what I can say is that, well, on this aspect, I'm raising a complaint regarding this issue. Now, in isolation, that simply an argument can be made that, hey man, somebody was ill or somebody died or something happened, and that you can say, all right, that seems reasonable. However, over numerous issues that have been like in a culminative effect of all these like failure shows that this maybe is not unintentional, maybe this is with intent. And that's ultimately my aims and objectives of bringing the complaint to yourself, is to get responses from them to see what their answers are. Because one time we can make an excuse, all right? 2 times you can say, all right, but that's coincidental. But 3, 4, 5 times when somebody's doing the same thing, then it shows intent. And that's all I'm looking to try to determine here, is intent on their part. Because obviously, I'm looking to prove intent, not because I know that they were acting under instructions or with malevolence. So coming back to the complaint issue, you've told me that, look, if they have responded to a subject access request, we can't investigate that. And I'm saying, I'm not asking you to investigate that, because that was not something that you would be, that's not in your remit. That is something that I've explained to you would be investigated, and you understand, by the Information Commissioner's Office. So that's not what I'm asking. The complaint rule relates to service delivery. Now, if a client is asking for disclosure, simply asking the question, can you justify that as part of the service delivery that to your client who's the complainant here can you justify and corroborate or validate that disclosure transparency did take place? And one of the aspects of transparency is that, for example, if the solicitor's firm saying, no, he's talking a lot of rubbish here, all right, we've provided him with everything, he has a copy of everything, and we can evidence that. So therefore, the service delivery, the complaint fails on my part, because they've provided me with everything. If part of the service delivery of transparency, moving away from the legislation and everything else, is that, look, this is your client, all right, you're saying that you provided him with everything. One of the things that he's saying you're not provided him with is that your costing. Now, did you provide him with your costing? And they can either say yes or no. If they're saying, no, we didn't, then they say, well, why did you not provide him with the costing? All right, let's move away from the legislation of the Data Protection Act. And they can say, well, for these reasons. But they have to give a reason, because the fact remains is that I do not know how much money they made, and I think I should have a right to have that information. Now, so it's not an aspect of, they didn't comply with the legislation. It's the aspect of service delivery, that they have not acted in an open and transparent manner. They've not provided the quality of service that I require from them. And one of that quality of service is that if I'm asking them a question and they are not answering the question, that is an element of lack of service delivery. Because if I can evidence that on this particular date, I asked this question from them, and there are numerous written questions in email that I asked them, and they failed to simply even address them or respond to them, that is a complaint that you have agreed with me that you can look into investigate. Because one of the things, just for your reference purposes, some of the information that they've provided you with is only written information, isn't it? That's the only information. That's the only information that they've documented. They've documented, for example, when I've called, they've documented what notes were made by the solicitor. They've documented, paperwork. That's correct, isn't it? Yes. Can I just confirm?
Yes.
Can I just confirm? Have they disclosed to you the telephone recordings?
No.
Okay.
No, they have not.
Okay. Would they be required to disclose the telephone recordings?
They wouldn't be required, though. So essentially, how we investigate complaints with this thing is we would break down the complaint into specific points. Then I would send a letter out to you and the firm, and I would ask you both to provide evidence for that complaint. So you to provide evidence that there was a service failure, and for the firm to provide evidence that they gave a reasonable service.
Yes.
Now, what they provide me is up to them, whether it's phone recordings, emails, letters. As long as it's up to them what they share, and equally it's up to you what you share with me.
Okay, so thank you for that clarity of understanding. So it's all to do with evidence, isn't it? And thus, hence why sometimes, so as a solicitor's firm, evidence is the bread and butter of their business operations. But can you understand that lack of evidence, or there's omission and commission. So if you commission something, there's evidence for that. But that when you don't do something, or if you omit something, there's no evidence for that. But the fact that you didn't do it is evidence in itself. So in a roundabout way.
Of course. So if you ask for, if you, for example, ask for a question and the firm tell me, well, we did answer him, but then they can't provide me evidence of any communication to you. That again, like I said, is omission. There's no evidence, so that tells me that they didn't respond.
Yes, so I was dealing with the solicitor's firm. I'm not dealing with, as you can appreciate, there are many other organizations out there that you deal with, and some of those are not legally or evidence based. So, for example, if I'm having a conversation with, I don't know, my GP, or not even the GP, let's say just somebody who's less professional, all right, then their whole bread and butter is selling products, let's say a retail outlet, all right, their bread and butter is selling products, so they're not so much evidence based. However, a solicitor's firm is one of the organizations that are the most evidence based, because that's their bread and butter. They write everything down, they record everything. So anything that they say can and should be evidentiable, because they know that that's how they make their money. They need to evidence things. So similarly, the point that I make this, and because I'm just conscious of the time, and I don't mean to be rude, but I didn't anticipate that the call would take so long, and maybe we can make another rearrangement. But what I wanted to say to you is that a lot of the information is omissions, because service is not about delivery, it's all about complaints. Often in this regard are omissions. Omissions are not by their very nature are not evidence, because there's no evidence that somebody didn't respond. But I can say that, look, I asked this question and you did not respond. But I think what I'm trying to explain to you is that every single telephone call that I made with the solicitors was recorded, and they were made maybe directly aware or not aware. So all my interactions were recorded. So every time, for example, every time I rang up the solicitor's firm and I left a message with the reception, that was recorded and documented. Every time that I rang up and it was not recorded, nobody picked up the phone. They don't have that information to provide you, but I do, because I know on this particular day I rang up and they didn't respond to anything. So right now, and I hope you're appreciative, and I hope you respect that it's getting a bit late, and I've been talking for a long time and I'm a bit tired, so hopefully we can rearrange this. But what I wanted to say as a first point of contact, I provided you with some evidence recently. I provided you with my criminal report to the police, Great Manchester Police, regarding what I believe was happening with the solicitor's firm. What also I wanted to disclose to you is that, obviously, like I said, everything was recorded. And at this stage, obviously, I would like to make yourself that information available. Now, as you can appreciate, I'm not a solicitor, and I'm as a private citizen, I am not required to write things down. And I appreciate you, Sian, in your private life, as a private citizen, don't go around writing everything down and recording things. But I do. All right, so that's the difference between me and most other citizens and civilians, because I also am a very evidence-based individual. So I don't say things or make complaints or take my time and resources into doing things without it being evidence-based. So just while I'm on the subject, can I ask, is this call being recorded by you?
It is, yeah.
Okay.
Sorry, I should have disclosed that.
Yeah.
All our calls are recorded.
Yeah, as you can appreciate, under the Data Protection Act, that should have been made available to me, but it's just an oversight on your part. I appreciate that. But ideally, if the calls are being recorded, this is evidence as well. And just for your information, I don't normally disclose this information because I'm not legally obliged to disclose this information, but this call is also being recorded by me as well. All right, just for your information. There's nothing malevolent about this. You were required to inform me that the call is recorded. You didn't do so, but I'm not going to hold that as an issue, yeah, because sometimes people forget, and I appreciate that. But just from my perspective, I want you to know that all my calls are recorded, and this seems to be an aspect that is the actual heart on the problem with myself and the authorities, is that it's an aspect of control. And so I make it quite clear when I need to that, look, I'm recording this conversation, and often sometimes Sian, it's my policy to publicize. I mentioned to you that I have a YouTube channel, so sometimes I publicize things as well on the YouTube channel. Now, just for your reference, it's not necessary for me to publicize this recording, but should I choose to do so, that's something that I will be doing, and that doesn't require your consent or permission, because often some people think that it does require their consent or permission, and it doesn't do so, because like I said, I'm quite averse in the law. But I just wanted to have that disclosure conversation with you, because I'm not trying to hide or manipulate you or trying to act in a malevolent manner. And similarly, with regard, and the reason I've just come on to this subject is because all my conversation, all my interactions with the solicitor's firm were recorded. So, it's an evidence-based thing that, obviously I'm coming to yourself that I recorded all those comments, and if you would be accepting of that, I would like to disclose those recordings to yourself and provide you with further information. Would that be acceptable to you?
Yeah, of course. Like I said, what we need to do now, Mr. Sain, is agree on your specific complaints. We need to agree on what complaints we're taking forward and what we can investigate for you. Once we've confirmed those complaints, I will speak to the firm and confirm to them what complaints we are investigating. Give them opportunity to offer their comments at this stage. I will put forward that you're requesting as a resolution to this complaint for all information. Give them a chance to respond to that, and then if we can't resolve the complaint at that point, my next stage would be to confirm your complaints in writing to you, and then make an evidence request. So at that point, you can submit anything that you think is relevant to these complaints. So recorded phone calls, emails, letters, whatever you think is best. But what we need to do is agree on the complaints we're going to investigate for you. Complaints that we've discussed here that you've mentioned about, the firm must be transparent, isn't something I can look into. We need to be more specific. So more specific questions such as, the firm did not disclose a cost breakdown to you when you requested. That is a specific complaint we can investigate. So we do need to just confirm the specific complaints we are going to investigate for you, okay?
Well, like I said, I'm not familiar with the process. I'm sorry if I've gone on about other things. I needed to provide you with some background and some clarity. Like I said, as part of this call today, I wanted to raise the less serious of the aspects of my complaint, which was obviously simply to do with disclosure and transparency. The more serious aspects of the complaint I've still yet to address with yourself, and following that second set of discussions, you will then obviously look to write all this up, and so we can have agreed terms of reference. So then once those terms of reference are agreed, then you can look into getting a response from the other party before your investigation commences. And once your investigation does commence and you have a response from the other party, that will allow you to be focused in on what they're saying, what I'm saying, and then I can at that stage provide you with further information. Now I have that clarity of understanding. That is correct, isn't it?
Yes, correct. Yeah. So the most important thing right now is I understand that you're short of time, but we do need to just confirm your complaints. Once I've confirmed them with you via telephone, I'll speak to the firm, communicate to them what your specific complaints are. I'll put forward your idea of, them releasing the information to your subject to access request. We'll see how they respond, and then if we can't resolve the complaint at that point, it goes to what we call an evidence stage, which is I will send out writing to you and the firm, your complaints in writing, and then make an evidence request.
Okay, that's fair enough.
And then once I've received all the information, that's when I'll start reviewing everything together and coming to my own findings.
Okay, so Sian, can we arrange another follow-up call from today? Because like I said, I've not really had an opportunity to go through everything.
Yeah, of can do tomorrow, Mrs. Sian, if that's okay with you, or Friday.
Tomorrow, what time?
At any time at the moment. I do have a call booked in the afternoon, but I'm free in the morning.
Morning's not really good for us. What time does your call finish?
Well, we haven't specified a time. We're normally between 12 and 2 at this time, so I could probably call you after 2 o'clock.
2 o'clock tomorrow, yeah, that should be fine. Tomorrow at 2 o'clock, would that be okay?
2 o'clock.
Okay.
Of course, and what we'll look to do, like I said, is confirm your specific points of complaint.
Yes.
Hopefully the call should be a bit shorter.
Hopefully.
I won't keep you too long.
Okay, that's fine.
Confirm your complaints, and then I can try and speak to the firm and get this moved along for you.
Okay, thank you very much, Sian. Thank you. I'll look forward to speaking to you tomorrow.
Yes, look forward to speaking to you tomorrow. Thank you, Mr. Sian. Thank you.
Goodbye.